ban on abortion that will go into effect if the United States Supreme Court wholly or partly reverses its precedent preventing states from banning abortion. While we have never repealed our pre-Roe v. Wade abortion prohibition statutes, a non-binding Fifth Circuit Court of Appeals opinion suggests that the legislature has effectively repealed the pre-Roe statutes by passing laws that govern abortions on minors, by regulating abortion facilities, and banning state funding for abortions in Medicaid. If the Supreme Court changes its precedent and allows states to protect unborn children, Texas needs a law to ban abortion to the extent allowable under the new precedent. In House Bill 1280, performing an abortion is a second-degree felony unless the unborn child dies, then it is a first degree. The person performing the abortion is also subject to a civil penalty of not less than $100,000 for each violation. Members, I've been asked a few questions about this. I'm more than happy to take any questions.
Mr. Turner, for what purpose?
The gentleman yield for some questions.
The gentleman yield for questions.
I do.
The gentleman yields.
Thank you. So, Representative Caprileone, this bill is basically a prospective bill. Is that right? I mean, it's saying if there is a future Supreme Court decision, then we'll have a new statute on the books in Texas. Is that essentially?
That's right. I guess we call it a contingency mechanism, but it's prospective on the basis of a future.
How many other issues have we done that for? Other subject matters have we done that for in the legislature, where we pass a bill and say if the Supreme Court does this someday, then we'll have this law in effect? When have we done that before?
So there's nothing novel or unusual about Texas providing a law that will go into effect upon a future contingent event. This is done in a variety of different contexts. Texas, for example, has made statutes that take effect. We've done it in the budget just recently, but also upon identifying and securing adequate state funding, on federal funding, or both. We've done it based upon the concurrence of other states, in terms of ratifications, or the concurrence of other states and the federal government. Sometimes we do it upon the enactment of federal law, authorizing imposition of a sales tax on remote sales, for instance, that we just recently did. In addition, Texas has made certain provisions of criminal laws that take effect upon a future contingent event, which is the case under the Texas Controlled Substance Act, which automatically adopts the classification or reclassification of drugs by the Attorney General of the United States under the Federal Controlled Substances. Now, none of this involves an improper delegation of legislative authority under Article 2 or Article 3, Section 1 of the Texas Constitution. I'll also point out that more than 90 years ago, the Texas Supreme Court noted, quote, "The authorities hold that while the legislature may not delegate its power to make a law, it may enact a law to become operative upon a certain contingency or future event."
Okay, thank you for that answer. I think those are interesting examples. I don't think they're a good parallel, though. I think, yes, we certainly pass laws that say, yes, if Congress takes certain action or if these funds become available in the budget, yes, that is standard operating procedure around here. But I didn't hear in that lengthy list of examples where you cite an example of where we passed a law that said if the United States Supreme Court does this, then we'll have this law in effect. So there's not another example where we passed a law based on a future hypothetical Supreme Court ruling.
Well, what I would say is that, the precedent, if you will, is broader than that. So again, the authorities hold, and this is the Texas Supreme Court, the authorities hold that while the legislature may not delegate its power to make a law, it may enact a law to become operative upon a certain contingency or future event. They did not say except for a Supreme Court ruling.
Okay. So let me ask you this, Representative Caprileone. Do you expect there to be a ruling overturning Roe v. Wade before the 2023 legislative session?
I'm personally hopeful and optimistic that there are a lot of cases headed towards the court right now. I think someone had told me, so I'd have to verify it, but somewhere around 63, 64 cases related to abortion, prohibition of abortion in different various ways that are, through different courts, appeals courts, headed their way to the Supreme Court. I do think If you go back, it seems like a long time ago, but in November, and even right before November, the whole entire country had a conversation about the Supreme Court, picking the Supreme Court nominees, and why it was important for that to happen either before or after the election, right? I mean, we can all remember
I recall that,
all of that case. And so I think the expectation for a lot of voters at that time, I mean, to some extent, I think is accurate.
So it's possible.
I think it's absolutely possible. I think
possible.
a lot. I do think it's
just
possible.
as you hope it does, I hope it does not happen. But my question, Representative, is if it happens, if you get your wish, and the Supreme Court overturns Roe v. Wade, do we have some reason to believe that Governor Abbott would not call the legislature back into a special session to address this? My guess is he would, based on his public comments on this subject matter. Is there a reason that we would take away the ability of the governor and the legislature to have a special session, if that's what the governor wants to do, to debate this very important issue at this time? Why are we closing off that possibility for ourselves?
Well, I think with this, the point of this bill and the point of a contingency is so that wouldn't have to happen. We, the legislature, would be able to say this is the law without requiring a special session. You know, and I hope to God, and I know we all do, that we don't deal with the same situation that we just dealt with over the past year with the pandemic, but in some cases we may not be able to meet in a ready way. It might become something that becomes difficult to meet in a special session for other reasons. Maybe there's other legislation or other things that could prevent that from happening. But at the end of the day, we're here now, right, Representative Turner? And I think on some other things, we agree that the legislature should absolutely work on legislation, should work on laws, because we're here now. And so that's what this bill does.
Sure.
It says we're here now.
So let me shift gears a little bit and ask you about the penalties in the bill, and you laid it out. But
I'm sorry, can you say that again?
The penalties in the bill. So
yes.
So if this law becomes effective, so it makes it a second-degree felony for an individual that knowingly perform, induce, or attempt abortion, right?
That's right.
And then if the fetus does not survive the procedure, then it's a first-degree felony.
Well, and by not
Is that
surviving
right?
the procedure, I think what we say and what the point is, if the child is killed.
Right. So what are some other second-degree felonies that we have on the books in Texas?
I'm not advised on all of the second degree, but I would assume
Just an example or two.
attempted murder.
Attempted murder? Okay. Any others?
I'm sorry, I don't have a list of all the second degree felonies here.
So a medical...
What I would say is that's what we're putting in this bill.
So an
And
established medical procedure would suddenly be on the same legal footing as attempted murder.
I'm sorry?
Your bill would make an established, safe medical procedure on the same legal footing as attempted murder.
If you go back to what the point of this bill is, what the Supreme Court has done is it ruled that states can decide that states would be able to prohibit abortion. And so what we're making a second degree felony is an attempt by someone to murder a child.
And is there any, we had discussed a bill earlier today about the point in a pregnancy in which an abortion would be legal or illegal. Does your bill make any such distinction?
It
in
does
terms of the time
provide a little bit of a difference in terms of, for instance, if there's a reasonable risk, life-threatening physical condition aggravated or caused by arising from a pregnancy that places the female at the risk of death. And
okay, is there an exception if a woman has been a victim of rape or incest?
there is not that exception. And what I would say, Mr. Chairman, is that in the rare cases of rape and incest, the right response, I think all would agree that the right response is compassion for both the mother and the innocent unborn child. And quite frankly, executing an innocent child for someone else's crime is not justice.
Right. So you said rare, and we hope those crimes are rare, but you would acknowledge women are victims of rape and incest in the state of Texas.
I'm sorry, I can't hear you.
I said while they may be rare, and we hope that they are rare, you do agree that at times women have been and continue to be victims of rape
Yes.
and incest in the state of Texas.
Yes.
That is a crime that will
It is a crime in
unfortunately
Texas.
continue to happen, most likely.
I hope not, but yes.
Well, I hope not either. But your bill doesn't provide any exception for a victim in that circumstance.
It does. What we're trying to do is we're protecting the child.
You're trying to protect the child.
Regardless what we want,
of the
of
impact
course, what we
on
want,
the-
of course, is to
regardless
arrest,
of the impact on the
incarcerate
woman who has been
the
raped.
offender. But what we want to be able to help, in those cases as much as we can, the woman who is sexually assaulted. But we also want for the child to live.
Thank you.
The following amendment, the clerk read the amendment.
Amendment by Slayton.
The chair recognizes Mr. Slayton to explain the amendment.
Members, this amendment is a very simple amendment. If you intend on voting yes on this bill, it'd be very easy for you to vote yes on this amendment. This amendment simply changes the timeline from, well, let me just say this. If you plan on voting on this bill and you want to save life in the womb, date uncertain, next year, 5 years, 10, 15, 20 years from now, all this bill does is speed up the timeline, and we would save life in the womb this year.
Mr. Speaker,
Mr. Moody, for what purpose?
raise a point of order against further consideration of the Slayton Amendment under Rule 11, Section 3 on the grounds that the amendment changes the original purpose of the bill.
Please bring your point of order down front. Mr. Moody raises a point of order against further consideration of the Slayton Amendment to Committee Substitute House Bill 1280 under Rule 11, Section 3 of the House Rules on the grounds that the amendment changes the original purpose of the bill. Mr. Moody argues that the purpose of the bill is to ensure that there is no gap in state law if and when a judgment of the United States Supreme Court or an amendment to the United States Constitution authorizes states to prohibit abortion. The Slayton Amendment would make the bill's prohibition on abortion effective September 1, 2021, regardless of any court decision on a constitutional amendment. The purpose of the amendment is exactly opposite of the purpose of the bill. Accordingly, the point of order is well taken and sustained. The chair recognizes Ms. Weiner to speak in opposition to the bill.
Members, I am fairly certain that I have given birth more recently than anyone else who serves in this chamber. Many of y'all have met my daughter, Lark. She's almost 3 years old now. And I'm so grateful to have her in my life. Being pregnant with her was one of the most vulnerable experiences of my entire life. Especially, as many of y'all know, I was on the campaign trail in a moment where we were all talking about maternal mortality. I was touring the hospital maternity wards, asking questions that kind of scared the other women on the tour, about where the hemorrhage kits were stored and what their preeclampsia protocols were. Now, neither of those were the complication in pregnancy I had. The complication I had was called hyperemesis. Y'all probably know it more commonly as really bad morning sickness. Whoever named it morning sickness, I'm mad at them because that's a lie. For me, it was 24 hours a day. I was so sick that I vomited more than a dozen times a day. I couldn't eat anything for weeks. I lost 20 pounds. You know, at this time, my pregnancy wasn't public yet. I had folks walking up to me telling me how great I looked. And I was just like, y'all, I just want to be able to eat and be able to keep it down. It was hard. It was really hard. And there were days I woke up in the early days of this so desperately wanted pregnancy and didn't know if I could make it to the end. We've talked a lot about heartbeats today. The first time I, through a Doppler device, heard a heartbeat sound from my daughter, I didn't enjoy that moment. I was trying not to vomit from the pressure of that device on my stomach. I bring this up because, especially having that type of complication, being on the edge of hospitalization, being so weak, it was all I could do to get myself from the bed to the bathroom. Knowing abortion was available in the state of Texas made me feel safer. It made me feel safer to know that I had options.
Members, please take your conversations outside the chamber.
It made me feel safer to know that I had options if the hyperemesis got worse, if I reached the point where I couldn't keep fluids down. And I know this isn't something folks are particularly familiar with, but this is a condition that used to kill women. Charlotte Bronte being a notable name. And again, abortion being accessible made me feel safer and made me more certain that I was going to get to the end and that I could find a path and that I had choices if something else went wrong. And luckily I got through that and enjoy my wonderful daughter today. Part of why I bring this up is when we heard this bill and others in the Public Health Committee, we heard the story of a woman who was already a mother caring for a toddler who was pregnant and had horrible hyperemesis and had to make the choice between being able to get out of bed and take care of her toddler or continue the pregnancy. That woman made the choice to take care of that child who had already been born despite her illness. She made the choice to have an abortion so she could take care of that baby. Members, as the member who has most recently had a baby in this building, I get asked by y'all all the time when the next one's coming. And there won't be a next one for me because I was so sick, and I know if I get that sick again, I will be in that position. That's what that choice means to women in this building. Everyone's abortion story is different. Every single one of them. And every one of us in this room has a different standard for what we believe constitutes an ethical and moral decision to have an abortion. But instead of trusting women to know their own circumstances, their families, and their own values, this bill makes the government the final arbiter of individual and intimate morality. Members, is trusting women really that unthinkable? We know what our families need. We know what we need. This bill would force a woman to carry a pregnancy that resulted from rape to term. Now, there are some women that is the right choice for, but there are some women who are going to struggle to wake up every morning and have the evidence of a horrible assault on their body. Members, this bill would force a woman whose fetus had been diagnosed with a severe abnormality, inconsistent with life, to carry that pregnancy to term every day, knowing that she would never get to hold that baby in her arms. And we've heard today about one of our own colleagues who made that type of choice. And it was the right choice for her. And it's not the right choice for every single woman. Do you really want to take that away? Members, this legislation would force a woman who is in such difficult circumstances because of the pregnancy that she is considering taking her own life to carry that pregnancy to term. I know we talk a lot about postpartum depression in this building, but depression during pregnancy is also a serious concern for women's health. This bill specifically carves out risk of death from self-harm from exceptions that would allow an abortion. Members, this bill would force a woman to carry a pregnancy to term if she knows she doesn't have the resources or the options or the support to care for that child. It would force her to carry that pregnancy to term if she knows that that pregnancy will have permanent impacts on her health and well-being. The only exception in this is for life-saving, not debilitation. So members, I ask you why. We have a lot of conversations about abortion in this chamber, but this is the most extreme. This is taking away every option. This is saying to every woman in the state of Texas that you don't trust them to know their own circumstances and their own needs. Members, I'm 35. Unlike some of my colleagues who spoke about this earlier, I grew up taking access to abortion and birth control as well for granted. Those were obvious things to me. Some of you know, grew up pro-life, grew up believing that abortion should be illegal, and walked away from that as I realized more and more the rights that we need to have over our bodies. Members, there are women across Texas who take this right for granted right now, who take for granted that if they are pregnant in a circumstance that doesn't work with their life, who take for granted that if they become pregnant and there's a severe fetal abnormality, who take for granted that if they become pregnant from a sexual assault, that they will have access to abortion. I know there's a lot of voices in your ears right now about people advocating for this legislation and telling you why it's needed. But members, you pass this and you're going to hear the voice of women who have taken this right for granted and have realized that they have to fight for it. So I ask you to keep those voices in mind. I ask you to think of women like me in their 30s and 20s and their teens who have assumed that this is settled law. And ask yourselves, what happens if it's not? What happens next when women decide to stand up for these rights again? What happens when women across Texas say no more? Members, I urge you to oppose this bill and instead affirm your trust in the women of Texas to make their own decisions instead of passing them off to the government.
The chair recognizes Ms. Johnson of Dallas County to speak in opposition to the bill.
Thank you, Mr. Speaker. I want to address my comments not to the people of this body, because many don't listen, but I want to address my comments to all of the young women out in Texas watching tonight who are searching for words of comfort from this building. I can only imagine the fear and the anxiety that some of you feel now and that many will feel in the future. High school girls who are pressured into sex in the football parking lot, but we failed you because you don't have access to the birth control that you need. Afraid about continuing your education, but this body failed you because we refused to pass a bill last session that would have provided the resources for you to complete that high school education. Afraid about medical care, but we failed you there too because we can't seem to pass Medicaid expansion to get you access to the health care that you need. Afraid that you can't get a job so that you can provide for your child with the high school education you were not able to complete. Because we refuse to pass a minimum wage law that lets you earn a living and keeps you out of abject poverty. Afraid that you can't get a job as a single mother because we make it harder, because that employer may not have to retain you because it violates a sincerely held belief that unwed women should not be mothers. Worried about where you're going to live because we make it harder, because we refuse to address affordable housing. Worried about the child care. Who's going to take care of this little baby? Because we refuse to address the complete lack of affordable child care in this state. But I want you to know out there, that young woman afraid, unsure of what to do, that we, the Democratic women, alongside our Democratic men, will fight for you every day to address these concerns, because not only having this baby, but your life is important, and the quality of the life that you live is important, and the ability to be the mother that the state of Texas is going to force you to be is important. We understand your fear, your worries, and we share them. And we will fight with every breath in our bodies to help give you the support you need as you cope with unimaginable difficulties as a result of the bill that is about to pass. And maybe, just maybe, we could actually achieve some of these things to make your life a little easier one day. Thank you.
The chair recognizes Mr. Capriglione to close on the bill.
Thank you, Mr. Speaker, members. I actually didn't have a closing speech. And I was thinking about what to say, and for the first time in a few days, my oldest daughter called me just a few minutes ago. She's 17 now, and I was thinking about when she was 11, and I would help her with her math when I was sitting on that side, and then I was thinking about when she was born, because that's when I realized how important it was that we fight for life and that we fight for our children. And there's no day that goes by that I don't worry, right? I have 3 daughters. That's what I do. I worry about them. So I understand a lot of what some other members are worried about and the potential situations that people get into. But this session, I've had the opportunity to work on a specific part of our budget, Article 2, where we do a lot of the things that we need to be doing to help women, to help children. We are, as a body, on our budget and in a lot of other bills, we do focus on women and we do focus on children. We focus on daycare. We focus on our public schools. So we are going to do, and we have always worked on making sure that we take care of our children. What this bill does, at the end of the day, what it does is it says that when the Supreme Court overturns, in my opinion, the worst ruling ever, but as soon as they overturn Roe v. Wade, our laws are all set. We don't have to come to a special session. We don't have to have a vote. We've made it clear that Texas is pro-life, pro-women, pro-children. We're Texans. I would appreciate your support on this bill. I move passage.
The question occurs on passing engrossment HB 1280. Record vote has been requested by Ms. Noble. The clerk will ring the bell. Show Ms. Click voting aye, Ms. Noble voting aye, Ms. Hull voting aye, Ms. Swanson voting aye, Ms. Capri-Glenn voting aye, Dr. Alderson voting aye. All members voting. All members voting. Show Mr. Harris voting aye. All members voting. There being 80 ayes, 64 nays, HB 1280 is passed on engrossment. Ms. Cole,